Welcome, everybody. Welcome. Thank you guys for joining us. I'm assuming Celeste will be on here momentarily. I see her. I just don't know if she realizes that she's muted. But as soon as she jumps on, we'll get started.
I'm not muted anymore, am I?
There we go. Fantastic.
Yeah. Hi. Let me see. Hello, everybody. Let's see. So welcome. Everyone can hear me, right? I'm hoping so. Yeah, I'm here. I'm seeing some hellos. Anyway, I really want to welcome you to this webinar number 2, MBE Basics. Let me introduce myself first. I'm Celeste Pagano-Bowles. I'm an instructor and content creator here at BarMax. I graduated from Harvard Law School, and I've worked as a lawyer and a law professor. I taught contracts and property, among other courses. And I've been teaching the bar exam for the last few years now. In our first webinar, Mayron, who is the founder of BarMax, he gave great information about changes to the bar exam that are happening or that may be happening because of the current COVID-19 crisis. And he answered a bunch of questions and gave some advice based on that. So definitely, if you have not seen that, do go back and watch it. And of course, keep up with your jurisdiction's website frequently for any updates that they might have. Today in this webinar, I'm going to focus on the multi-state bar exam portion of, the multiple choice portion of the bar exam. And in future webinars, we'll talk about the writing portions of the bar exam. And then finally, one more housekeeping matter before we get started. You're going to notice you have different boxes. There's chat and there's Q&A. So I'm going to be looking periodically throughout my presentation at the Q&A, and I'm going to pause and answer as many of those as I can. Now, I have a lot of you here today, so I'm going to try to get to as many as I can, but focus those on the MBE, the multi-state bar exam. We have other wonderful people from BarMax who are monitoring the chat portion of this, webinar. So if you type something into chat, if you want a general question about BarMax or about the bar exam beyond the MBE, you can go ahead and type that into chat, or if you want to say hello or say hello to other people. But just so that I can manage my attention and give you a great program, I'm going to focus my Q&A mostly on what gets typed right there in the Q&A box, and I will try to answer those out loud. And because we had a lot of you registered today, I'm not going to be taking raised hands, at least at this point. I'm going to see if I manage that Q&A box well. Maybe I'll promote myself to raised hands in a future webinar. And we'll see how that goes. So our agenda, I've written it on here. This is our agenda for today. I'm going to give first a very broad overview of the exam and a little advice about how to think about scoring. And then second, we're going to walk through the 7 subject areas tested on the multi-state bar exam and the scope of those subjects, the sources of law that are tested there, like which portion of the law do you need to know? And then finally, and this really is where the bulk of my material is, I'm going to talk about how to study for the MBE. And specifically, I'm going to show you a study method that is uncomfortable for most students to transition to. It's different from what they've learned in other bar prep programs or how they're accustomed to studying, but those who do find it to be very effective for really understanding the frequently tested material. It does begin by using all real questions. That was one question I did get in advance. Should we use real questions? Yes, absolutely. And every question in the BarMax program, app, or online is a real past bar exam question. But we'll go through how to study effectively from those questions in the third part of today's webinar. So let's see. So what is the MBE, the Multi-State Bar Exam? It's created by the National Conference of Bar Examiners, or NCBE, and it is the multiple choice portion of the bar exam. It is used in every US jurisdiction except Puerto Rico and Louisiana. So that's 49 states, the District of Columbia, and all the other territories do use the multi-state bar exam. And so this should be helpful to a lot of you. It tests 7 subject areas, as I said, and now it's changed over the years, but now there are 25 questions in each subject. Now you'll sit down and you'll take 100 questions in the morning and 100 questions in the afternoon. That's 200 questions. And if you're good at math, 7 subjects times 25 questions is only 175. So of these 200 questions, 75%, or 175, I'm sorry, I'm already getting to percent, so I can talk about what's down below, but 175 are real. Okay, the other 25 are tester questions. The NCBE tests questions numerous times. They slice and dice statistical analysis, they change words. So sometimes you'll see a question that doesn't work logically, or 2 answers are correct or whatever. That may be a tester question. It might be a real question that you're just having trouble with because the real questions are plenty hard. But as you go through, you don't know which 25 sprinkled throughout your day are tester questions, but your score will be based on 175. Now, I put that 65% will pass, but that really depends. People say, what do I need? You know, how many percentage of MBE questions do I need to get right to pass? And the answer in true law professor question that I will, in true law professor fashion, I will give you the answer. It depends. It depends on a lot. It depends on your jurisdiction and on your writing, and then to a certain extent on the statistical adjustments that NCBE makes in any given year. The reason it depends on your jurisdiction and your writing is because obviously what score is required. For example, on the UBE, your jurisdiction may require something like 266 to pass. They may require a little less, they may require a little more. On the UBE, just as an example, it's half essays and half multiple choice. So if you're going for a score of 266 or above to pass, and you do exactly the same on both sections, if your strength is exactly balanced between both sections, then you'd need at least a 133 on each section. But the reality is you could pass by doing very well in the writing and a little bit less in the MBE. Only 2 jurisdictions have a base minimum and MBE score separately. That's Kentucky and South Dakota. So for the rest of the jurisdictions, you can combine your writing and your MBE score to get the score you need. And then finally, what do you need? Like if it's half the test and it's 166, we gave that, or 266, we gave the example, you need a 133. That's probably about 62, 63%. Okay, again, they statistically balance the test year to year, so it may be a little different on your exam. But if you're taking practice tests and you're getting 62, 63% right, you're on track if your writing is pretty solid, right? And then for a jurisdiction like California, that's a little more demanding in its score. You might need that higher, that 65, 66%, if your writing is, right at the passing line and not above. And again, you can be below 60% if you do really well on your essays. So it depends, but it's good to remember when you're going through MBE questions And real questions are sometimes really hard that you don't have to get all of them right. If you get a third of them wrong, you're still passing most likely. So that's always just good to know. Not that we want you to get a bunch wrong, but we want you to feel confident that you're still on track to pass the test, even if your score is looking like that, it's fine. Let's see. So I'm gonna just, yeah, so California, 2000 point, blah, blah, blah. I'm just looking at my notes. I'm gonna take a quick look and see just if I have questions overall about the exam before we get into how to study and all of that good stuff. You know, how to, yeah, let me just see where we're at in the Q&A. Let's see. Some of this stuff is, okay, will we receive a copy of this handout or PowerPoint? No, but the, I don't expect that we're gonna pass that out, but we will have a replay of this posted. You'll get an email with a link to a replay. Do the MBE subjects differ depending on the jurisdiction? This is a great question. No, the multiple choice questions that are tested are the ones on this page, and I'm going to walk through them. And then if I'm taking the Nevada bar, what can I do to study for the rest of the exam? Okay, so what to do about state-specific essays is kind of outside the scope of this, but I do have advice about it. So if I have time, Rocky, I'm going to try to cover that toward the end. Are the questions broken up by subject matter or are they intermixed? Great question. Now that one, they're mixed and they don't tell you what it is. So we're going to talk today about how to know what you're looking at, because that's, you know, a good place to start. You want to know if you're looking at a constitutional law question or a civil procedure question. You can get it right without knowing, but it's better to know. And they don't tell you, and they're all mixed. And is there any way to practice with a Scantron? Mary, I bet you could find a Scantron form or a bubble form online that you could print out. I know it seems silly, but if it's what would help you, then find a way. This video is going to be available later on. Let's see. And then these look like more specific questions. I want just general questions about the MBE. I think we're good for now. So the opposite is true, correct? If you improve your MBE score, it gives you some flexibility in the writing portion, correct? The answer to that one, Mr. or Ms. Anonymous, is yes. The converse is also, or the opposite is also true. Okay, these are great questions. And I'm going to continue because, like I said, I got a lot of material on how to prepare. When we are looking at the subjects themselves, I've got them listed here. Civil procedure is federal civil procedure. Okay, so that's U.S. courts, or U.S. federal courts. It's not going to ask you about filing and such in your state courts on the multiple choice portion of the test. Now, if you have state-specific essays and not UBE essays, your state may test on your state's law. Some states do, but for the MBE, for the multiple choice portion, you only need to really know the federal rules of civil procedure and some case law based on that you probably know. If you attended a US law school, you know, you took the class your first year of law school, you know, the minimum contacts test is court created law, but it's all flowing from either the Constitution, what's the jurisdiction of the federal courts, or from the federal rules of civil procedure. So there's a little constitution, a little statute, but mostly the FRCP, Federal Rules of Civil Procedure, tested there, 25 questions. And then in criminal law, or what we call crimes, they divide it into criminal law and criminal procedure. And again, you don't know what a question's asking about, but the NCBE, divides it that way. Criminal law is crimes. What's the necessary mens rea of a crime? What are the elements of a crime? What are the defenses to crimes? And criminal procedure is the parts of the US Constitution and case law, Fourth Amendment, search and seizure, Miranda. Again, if you attended a US law school, some of these sound familiar, and hey, some of them sound familiar from watching movies. That's criminal procedure, US constitutional provisions that affect criminal defendants and the case law interpreting them. That's 25 questions altogether between criminal law and procedure. Contracts law tests the common law of contract. Pretty much, there's a pretty broad general common law of contract, and I've tutored students who actually got their law degrees in other common law countries, and from other common law countries, and discover that they already learned a lot of this in law school, as we did here in the United States. The part that you didn't learn in a common law country other than the US is UCC Article 2, which is the sale of goods. That's the one main statute that you'll need to know for the contracts multiple choice questions. Now, it bears mentioning here, what about the rest of the Uniform Commercial Code? UCC is the Uniform Commercial Code. Most jurisdictions have dropped what used to be called commercial paper, which tested Article 3 of the Uniform Commercial Code. So all that stuff about a holder in due course of a promissory note and blah, 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 I hated it and it's gone. That was my least favorite subject. So I was happy that it was taken away. However, Article 9 is still tested in a lot of jurisdictions. That's secured transactions. And that's also tested on the UBE. And in a lot of state-specific jurisdictions. So if your jurisdiction tests secure transactions, you're on the hook for Article 9 in the essays only. On the multiple choice, you only need to know Article 2, sale of goods. It's usually pretty obvious when it applies, because goods, tangible, movable items, somebody's selling a refrigerator, then you know that those are the rules you're going to apply. So you do need to know some of the distinctions and be able to apply either body of rules to a contracts question. Constitutional law tests a broad overview of US constitutional doctrines, the role of the courts, jurisdiction of the courts, the structure of, the role of the courts, the structure of government, powers of Congress, federalism and states' rights, the Dormant Commerce Clause, all of that, and then individual rights, First Amendment, and so on, freedom of speech and religion being big ones. So those, and then, equal protection and due process. So those are all tested in the 25 US constitutional law questions. But the parts of the Constitution dealing with the rights of criminal defendants are considered criminal procedure. So evidence, again, federal. You don't need to know your state's evidence law for the multiple choice portion. California, some other states are going to want you to know some state evidence law for your essays. But if you're taking the UBE essays, you just need federal. If you're taking the MBE, the multiple choice test, anywhere, you only need to know the federal rules of evidence. And again, some case law applying the Daubert standard for Daubert standard for experts. I'm sorry, I'm used to writing it. And, or things like that. So there's not much beyond the federal rules of evidence. It's a little tricky when you get to things like hearsay exceptions, but it's a pretty subscribed area of law. real property, test common law of property, some statutes. Real property is really big on knowing the majority and minority rule. You have to know both and how they apply. So 25 questions in real property, and there's a lot of doctrine in there. And then torts, test the common law of torts, and then some very common statutes that, you know, are of broad applicability across most states. I just want to give a note about the last thing on my slide here, remedies. It's not tested as a separate category. There's no separate questions, but it may be tested as part of contracts, torts, property, even constitutional law. Okay, if you see a question about process, like how to obtain an injunction, that's a civil procedure question. But if you see a question about, you know, can this person get damages? Can they get restitution? Are punitive damages available? You know, can they get an injunction or specific performance? Those are kind of remedies issues that can come up broadly across all those different subjects. So in BarMax, we have a lecture on remedies just to reinforce and tie together the remedies concepts you will have just reviewed in the other lectures. Okay, so I really am going to go through the study method, how to study next, and that's what we're doing here. But before I jump into it, I'm going to check the Q&A again, so I don't want to run too far ahead of everybody. And it looks like I got a lot of, which jurisdictions have a baseline minimum? So it is South Dakota and Kentucky. And then percentage pass rates. Okay, so we don't know for all of our students. I know we have some early data that, you know, we had students in New York who were doing very well with the earlier versions of this program, but I don't know the specific percentages. So that might get answered in chat. I don't know. Let's see. We don't have Hawaii bar specific material to the, you know, material specific to the state question, state essay questions for the Hawaii bar, any of the other non-UBE states except California. California and the UBE are the only ones where we have all outlines for all the subjects, but I will give some advice at the end about maybe how to best study in those states. Tactic, and somebody's getting ahead of me, Michael Orr, I'm definitely going to answer that. That's part of my presentation. But yes, we read the call of the question first, and we'll go through it. Will I cover how to improve MBE scores for retakers? Yes, Tamika. If you are a retaker and you did not use the method I'm about to show, then try it and see if it works for you. Okay. Are there more federal questions if you were in California? If you're in the California bar, a lot of the subjects that they test in the essays are just general. But yeah, and then some are specific to California. But we'll have a whole separate webinar about California essays to get you ready for that. But in terms of the MBE, the multi-state, the multiple choice portion, it will be the same in California as it is everywhere else. Only those 7 subjects tested on the MBE, yes, that's it. Just those 7 that I have right here are tested on the multiple choice portion of the bar exam. How is constitutional law? How could you test a remedy in constitutional law? It came up actually in an essay question, an infamous essay question. But you know, can somebody get an injunction under a constitutional law claim, for example? So there you go. That's a remedy. An injunction is a remedy. A remedy is just anything that someone is seeking as the outcome of the lawsuit, right? So it's, you know, something the court has to have power to provide, right? Does crimes include evidence? No, evidence is a separate topic. Yeah, so evidence is a totally separate class, and it is tested, as you see here, separately. And it's got its own 25 questions. This might be repetitive. Maybe some of these questions were asked before. Did the UCC drop, did California drop UCC Article 3? Yes, I think so. I think so. All right. Okay. So I've gone through a bunch of the questions, and I'm going to just go ahead and show the study method I recommend so that those of you who have to leave at 3, we'll be through it by then. And I'll try to take some of this other stuff beyond the scope of the MBE afterwards. Okay. How to study for the MBE. Number 1, use real questions. Sorry, I'm scribbling. I meant to, okay. Use real questions. The NCBE has only released about 1,600 real past MBE questions, but they're gold. They're really valuable. Why? Because NCBE loves to test the same sub-issues over and over again. They have for decades, and they will continue to do so. MBE questions are written with a certain logic in mind, and they are tested and vetted, as I said, ad nauseum. You only get 175 real ones, 25 tester questions. They slice and dice the statistics on those. They know whether it's an easy question or a hard question. They do a lot of analytics before calling something an actual test question. So the ones that they've released are good, clear, logically solid questions. There is a right answer and 3 wrong answers, even if we don't like it sometimes. And because of that, we really urge everyone to always study just from real questions. The BarMax app has all of them. Every one that's ever been released is in the BarMax app. And I'm gonna talk about civil procedure in just a minute, but if you have a program that has more questions than we do and is calling them real and MBE questions, they're not all real MBE questions, and it's most likely the civil procedures that are fakey jakies. I'll talk about why in a minute. The method that we recommend that people use is an open book method. This sounds crazy, but the goal is to get you involved in a more active style of learning. We want you to use these real questions to take an active role in your own learning. And it's gonna take a bit to coax yourself to do this. Believe it or not, you are used to, maybe not you, but most students that we've worked with are used to being more passive in their learning. They're used to going through, reading the question, whatever the way they read the question, selecting an answer choice and either moving on or just checking the answer and going, oh, okay, now I get it. Okay, we don't want that. We want you to slow down and convince yourself that the right answer is right and the wrong answers are wrong, and know why before you ever select an answer. And I'm gonna model doing that, but the reason why is because if you do it, you look at the rules if you have to, you do it slowly, methodically, and really use them as study materials, then you will remember the material as it's tested on the test. You'll have fact patterns to hang on to as you go through the rules, and the rules will make much more sense. When you read them disembodied in an outline and listen to a lecture, even a great lecture, like some of Arthur Miller's civil procedure lecture in BarMax, there are great lectures, but you're still not gonna remember it the same way you will or understand it as deeply as you will when you see it applied to facts. So you're gonna use the questions to teach yourself the material. So let's walk through that. I do recommend that people read the question stem first, okay, or the call of the question stem first, then the facts, and then the answer choices. Okay, some people like to read the answer choices after reading the question stem. Let me just stamp that out right now. Why not read the answers first? Because 3 of them are wrong. and they may be sending you on a hunt for issues that aren't there. They will crowd your brain with stuff that's wrong. Let's focus on what you're being asked and on what is actually given to you in the problem before we confront the answer choices. So just looking at why we would read the question STEM first, one reason is, I said I would talk about civil procedure, but I'm going to come back to that. One reason to read the question STEM first is because it's going to let you know what kind of question you're looking at most of the time. Okay, we read the question STEM here. Which of the following is the strongest argument that the state's action is constitutional? We know we're looking at a constitutional law question right off the bat. So we put our constitutional law goggles on, and in fact, we're looking at a state action. Another good call of the question, should the court admit the expert's testimony? We know we're looking at an evidence question now. And again, they're mixed up on the test. They don't label it for you. Okay, so you'll go into this. Otherwise, you might begin the facts here and say, a plaintiff sued the manufacturer of his lawnmower, alleging that as a result of a design defect, he was injured when we're already in torts mode. Okay, if you read this from the beginning, you think it's a torts question, and then you go, holy mackerel. This is, you know, somewhere along the way, you realize they're talking about an expert witness and, you know, some evidence, and it's an evidence question. You want to approach it as an evidence question from the get-go. So you know that it's either about expert testimony or about relevance, because relevance is always fair game in an evidence question. Now, that is not to say that all question stems, all call of the question are useful. How about this one? In this action, will the plaintiff prevail? We know it's not criminal law because it's got a plaintiff instead of a prosecutor, and actually it's probably not evidence or civil procedure, because it's asking about the outcome of the whole action and not just the outcome of a motion, or, you know, but come on, it could be torts, it could be contracts, you know, it could be property, it could be con law. That's not a helpful one, but we didn't spend a lot of time reading it. We just move on, right? This one here is a little bit more of a dangerous kind of useless question. It's not entirely useless, but look at this question. Assuming Glazier has no remedy quasi in rem under the relevant mechanics lien statute, which of the following would provide Glazier's best chance of an effective remedy in personam against landlord? It's probably a property question, maybe contracts. Oops, it turned out this one was contracts. But it gives you too much information. So don't even worry about cramming it all in your head. You're looking for a best chance at a remedy, okay? Don't let the extra characters or the extra words trip you up. You've read the call of the question. You're gonna have to read it again before you read the answer choices, and that's okay. Some of them are more helpful than others. This was actually, I think, a torts question over here, and this one was a contracts question, if I remember correctly. Anyway, so let's do a question. I've told you to read the call of the question first, and this happens to be one of those call of the question that comes like as a gift from NCBE. Some of them are useless. Will the plaintiff prevail? Some of them are beautiful. They come with a bow. If Sam's companions are subsequently tried as accomplices to manslaughter. Why is this beautiful? We not only know that it's a criminal law question, but we know exactly what we're looking for. We don't have to issue spot. We're looking for accomplice liability, and we're looking for manslaughter or attempted manslaughter. We need all of the elements of accomplice to manslaughter. So we should be reading for those, and then watch out maybe for any potential defenses that would apply to these so-called companions. Okay. In some questions, call of the question, They'll even give you the language of the statute. That mostly comes up in crimes. They'll tell you, in this statute, first-degree murder is defined as, then all you have to do is you're reading for the elements to see how the facts line up with those, how the facts line up with those, the elements that are given to you, okay? So what do we do next? After we read the call to question, we read the facts. Again, why don't we read the answer choices? We don't read the answer choices because 3 of them are wrong, right? But the facts are right. Facts are always right. Okay, we're bound by these facts. We're going to adhere to these facts. So here we go. Let's read them. Buckle up. Sam and 2 of his friends were members of a teenage street gang. They were returning from a dance late one evening. While they were returning from a dance late one evening, their car collided with a car driven by an elderly woman. After an argument, Sam attacked the elderly woman with his fists and beat her to death. Sam's 2 friends watched, and when they saw the woman fall to the ground, they urged Sam to flee. Sam was eventually apprehended and tried for manslaughter, but the jury could not decide on a verdict. Let's just pause here and say these are terrible facts. These are horrific, horrible facts, and they may have caused some kind of a gut punch for you, and that will happen on the bar exam. Okay, they're going to play with your emotions. They're going to try to get you on the MBE, on the multiple choice questions. You will see people who have done horrible things and are found either not guilty or not liable, in criminal law or tort. You will see horrible laws like, oh my gosh, that's a terrible law, which turn out to be perfectly constitutional, but they get you emotionally. And if you're not just thinking through the elements and thinking through the laws and what the rules are, you're going to find a way it's unconstitutional because you want to, darn it. Okay, so don't let them do that. Don't let them sucker you like that, okay? The solution to bad laws is better legislators, okay? I didn't mean to preach. So the one place on the bar exam where sneaky people do kind of usually get it is contracts law, because there's a good faith requirement underlying the law of contracts. So usually sneaky people don't get away with stuff in contracts questions, but terrible people may or may not be getting away with stuff everywhere else on the MBE. So we just have to buckle up and not let these people play with our heads, right? Okay, so now that we've dealt with these horrible facts, remember, we're looking for accomplice liability to manslaughter. Now, we're pretty sure we have at least manslaughter here because we do have a dead body, right? But what did these people do, these so-called companions? I circled it. They watched, and then afterwards, okay, because here she's beaten to death, right? And then afterwards, they urged Sam to flee. Okay. Now, at this point, we can read the answer choices, or we can stop if we don't know the elements of accomplice liability. We could stop and look them up right now, because we may not know what's relevant and what isn't. And we could stop and look it up right now. But let's say we're feeling confident. We're going to go ahead and read the answer choices. If Sam's companions are subsequently tried as accomplices to manslaughter, they should be acquitted because Sam was not convicted of the offense. Uh-oh. Imagine we don't remember. Is this a rule? It doesn't sound familiar. Okay. A lot of times if something doesn't sound familiar on the bar exam, it's because they're making stuff up, right? But if we're not sure of the rule, we're not sure at this point. Later on, when you've studied for a while, you've gone through enough questions and you see rules that you've never heard of before show up on a bar exam question, it's probably MSU, right? The bar examiner's making stuff up. But at this point, we're not sure. We can't eliminate that answer, let's say, if we don't know the rule. Should they be acquitted because they did not assist or encourage Sam to commit the crime? Well, that's all true. But they let this woman fall to the ground and die in front of her. They watched this punk beat her to death. They were with him. They urged him to flee. You know, we're not sure if this is the correct answer or not, if we're not really solid on the rule for accomplice liability. Convicted because they urged him to flee. Ooh. Does that mean something? If we're not sure, we don't know. Okay. So what do we do? And then convicted because they made no effort to intervene. What do we do if we can't choose between these answers? Or if we get down to two and we can't choose between them because we can't remember if some particular thing is a rule or not? Do we just pick an answer choice and then read whatever the test preparers or the test prep company gave us as answer choices? No. That's what's different about how you're going to study this time, my retaker there, and how all of you are going to study to use your time the best. You're going to use your time better by slowing down, okay? You're going to go into your outline at this point. Now, wait a second. I thought I had BarMax open. Here it is. Okay. I'm in a couple of lectures today, but we're talking about crimes, okay? So accomplice liability. So you see, this is the full course that you would get. This happens to be the UBE course, but we have a UBE course, an MBE only course, and then a California bar exam course. And they all basically look like this. If you have not yet downloaded the free app, you can see all this, except for here, I have access to everything. And until you pay, you don't have access. You only have access to sample material. Anyway, so let's say we're in crimes, accomplice liability. This is a lecture entirely about the inchoate crimes and accomplice liability. We need the rule for accomplice liability in order to answer this question. So looking at the lecture, we can see that A is attempt, B is solicitation, that's not what we're looking for. C is conspiracy, this is all good stuff to know, but not for this particular question. And we roll on down to D and we see, aha, accomplice liability. Okay, I'm doing this right now on the BarMax app. Some people do prefer working from outlines. So like, for example, here's the California outlines. They include all the MBE topics in addition to the California topics. We have the same thing for our other courses, right? UBE outlines. I'm showing you books because some people like books. You like to mark books. You like to write in books. You like to go, yeah, this was the one about Sam's companions who beat that woman to, or, when Sam beat that woman to death. Like, whatever you write in here to help you remember the rule, great, do it. If you sign up for the course, you get books as well as the app, or you can look at the outlines online through any web browser, right? And the app is, Android or Apple, we're everywhere, okay? So you can study in whatever way works best for you. So anyway, here we are at accomplice liability. You guys may have read it by now because you're ahead of me. Yeah, I've made it big already. Okay. If one aids, abets, or encourages or facilitates the commission of a crime with the intent that the crime be committed, one can be found guilty under a theory of accomplice liability. A conviction for accomplice liability requires not only proof that the accomplice aided a principal's crime. Okay, so we know we need this. Okay, we need some sort of aid and actus reus, but also a culpable mental state mens rea. It is important to note that I'm reading all this because this question, doing this question about Sam's companions, is my chance to brush up on this material and make sure it's really solid. Okay. Accomplice liability is not a separate offense, but rather an alternative way to be found guilty of the primary offense. There must be must actually be a crime that is attempted or completed in order to find accomplice liability. Okay, but I'm not sure that answers all my questions, so I'm going to keep reading. And here, some explanation of the parties. All right, we know that the principal is Sam. It says the party or parties who actually engage in the criminal act or omission. That's Sam in our problem. There is no requirement, oh, check this out, that the principal is actually prosecuted. So there you go. Our Sam guy wasn't convicted, but he doesn't even have to be prosecuted in order to find accomplice liability for the other parties. Okay, good. We know we're going to be able to eliminate that answer. I mean, we can do it now. Hey, why not? So now we know that this one's a bad answer, right? Just by being sure of the rule. Going back in here, we're like, okay, here's the accomplice. The accomplice is someone who helps before or during a felony, someone who, with the intent that the crime be committed, aids, counsels, or encourages the principal before or during the commission of the crime. I could have highlighted all of it, but okay, the key point being before or during. We definitely saw some encouragement in this fact pattern, but it was not before or during. And then we learn about the liability. An accomplice is liable for the principal crime, even if the defendant ultimately uses an alternate means to commit the crime. And then just to polish up our knowledge, we can read about an accessory after the fact, okay? Someone who shields, shelters, or assists another knowing the person's committed a felony, okay? And we can read about that, find out that it's a lesser, a less serious offense. It's not a way to be convicted of the principal crime, whereas accomplice liability is. Wow, we may have heard this all in the lecture, but it's really vivid to us now with this question in front of us, isn't it? Well, let's go and see if the answer choices aren't clearer to us now that we've taken the minute or 2 or 5 or 10, whatever it would take us to go and be sure of this material, okay? So should they be acquitted? We cross that one out. Should they be acquitted because they did not assist or encourage Sam to commit the crime? Should they be convicted because they urged him to flee? We realize that's not before or during. That happened after. We can cross that one out. And then if we had read a little further to the actus reus requirements, we would have found also that mere presence, mere failure to intervene at the scene of a crime is also insufficient. If we were not sure of this and couldn't confidently eliminate these answer choices, we should stop and look at our outline. Because by the time we did all that, we're very confident the answer is B. Now, maybe you were confident all along, you knew that rule, but the bar exam is hard. There's a lot of permutations and sub-rules and exceptions that you need to know, so look them up instead of guessing. By the time you select an answer, you should be able to tell someone. You should be able to convince yourself and someone else why the right answer is right and why the wrong answers are wrong, okay? And boom, there you go. Our answer choice B is the correct answer to this question. Okay, so I have other examples. I have more I want to talk about. I can talk about Civ Pro in a minute, but I kind of want to just get some of these general questions out of the way first, just so that I can make the first hour really useful to you. I got a couple of questions that were, how many questions should I do overall? How many questions should I do every day? Okay. Now that you've seen how I tell you to do one question, you can guess that we want you, at BarMax, we're urging you to focus on quality over quantity. Now, if you want to get through every single real MBE question that's ever been published, and you were going to start now and work 6 days a week, you would only have to do 18 questions a day, and you get through the entire bank of 1,374 MBE past questions that we have. Plus, there are another 400 that are the online practice exams. Those are, again, they're online, but we also have them in a book so that if your bar exam is in a book format, you can take them in a book format. I mean, the bar exam is usually in a book format, but we talked about, any potential changes yesterday. Anyway, so you have them online, or if you want to take it on a book. The point is they're practice tests. You'll do them closer to the time of the exam. That's 100 questions that you're going to sit down and do all at once, timed 3 hours. That's when you're testing yourself. That's when you're working on pacing. Okay, if you know that pacing is a problem, we can do some things. I'll probably do an office hour about that, about, some strategies to deal with pacing before then. But now, months before the exam, toward the beginning of your study, don't worry about pacing. Worry about understanding the material. Okay, students don't want to stop and look at the rule because they're more concerned with getting through a certain number of questions than knowing why the right answer is right and why the wrong answer is wrong. Okay, and it's just more important to do them well. Like, look, for example, in BarMax we have analytics. Let me go there. If you go to your little profile in BarMax, or you'll learn how to use the app if you have it or get it. There's an analytics section. And as you can see, I've only done 3 questions. That's because I clear my answers before I teach. But they'll show you how many you've done, the percentage correct. But what else is really helpful about this? Let's say you found out, gee, I really don't know much about mortgages. My property teacher didn't even get to mortgages, and come to find out it's a heavily tested area on the real property exam. Sorry, it is. Well, you go there and you see there are 22 questions. If you look in the upper left-hand corner, you can just work on those 22 questions. So guess what's a great number of questions to get done the day that you're focused on mortgages? 22, because that's how many there are, right? There's no need to say, I've got to do 30 questions a day, or, so really, whether you do 5 or 10 or 15 or 30 questions in any given day, or 100, because you're taking an OPE and, the online practice exam, depends on what your goal is each day, right? Is your goal to really, review and understand the law of mortgages? Then get through as many of these as you can, right? And then, call it a day. And if you can only get through 10 of these with your full focus and attention, then do 10. There's a lot of hearsay questions. If somebody rushes through 20 hearsay questions and kind of grabs at an answer and goes, okay, now I get it, versus someone who stops, looks up the rule, reads the rule, understands the exceptions, and does 15 questions, which one has a better comprehension of hearsay at the end of that study session? Okay, you know how long you can focus and study, and we don't sit on our butts for 8 hours. It just doesn't work that way. Our brains don't work that way. Some people's do, but you might need to get up, walk around, do something else. That's okay. BarMax is really flexible because you can buy it now for an exam that may not be until July or even September, or heck, for next February. You can spend all the time that you need preparing. We're not like most companies that say, okay, this is 12 weeks or however many weeks you can access the material. You can spend as much time as you need. You can work, take care of other family obligations, whatever you need to do while you're learning this material. Okay, so I have a ton of more material, but I know you guys have questions, so I'm gonna pause and answer them. And I hope you guys are finding my colleagues who are in chat to be very helpful as well, okay? Let's see. I'm sorry, I already answered some of these and I was supposed to dismiss them, but I'm learning how to do this. Does it, I don't know. Does it help if we get those tester questions correct? Is this video going to be available? Yes. I'm going to talk about if we already answered that. Note section of the BarMax court on a desktop. I don't know that the desktop has the note-taking feature. Yeah, I don't think it does. I think you need to be using the app or, you know, the good old-fashioned book that can take paper. California scores 50% for the MBE and 50% for written. That is correct. So I've answered your question, Michael. Read the call of the question, then the facts, then the answers. That's the tactic we recommend because we don't want you reading wrong answers before you solidify yourself on the facts. I do want to talk to what you do if you get down between two answer choices and you know the law, because it's usually a reading issue. So we'll get to that in a minute. Are the questions on criminal procedure case specific? Okay. You do need to kind of know the law as it has been shaped by various major Supreme Court cases. So like if you know about a Terry stop, that might happen on the bar exam, for example, things like that. So yes. Oh, thank you. I meant to do this at the beginning. David, thank you for asking me the difference between study mode and test mode. Let's look at some questions. Woohoo! This is me being a nerd. Okay, so I want you to see that in the upper right-hand corner right here, see? I'm showing an open book for study mode or a check mark for test mode. Okay, if you want to just do a set of questions like, gee, you know, as testing yourself, you can. But I really prefer that students be studying if you're trying to learn law and understand it and understand how it's applied in study mode. And when you study in study mode and you answer a question, you'll get answer explanations. Now, you'll notice, if you're being super observant, you'll notice that that particular criminal law question I did only had an answer explanation for the correct answer. It came from a more recent set of study aid questions. This one has answer explanations for incorrect and correct answers. So we have ELBs, I'm sorry, other content people like myself, but other ones working to fill in the answer explanations. We originally only had correct answer explanations because from there, you should be able to figure out kind of why something is wrong. I'm just picking randomly, okay? And if you can't, there's in the upper right, I'm sorry, I gotta show you. You can see right here next to this one, there's this little speech bubble. You can get questions with answers. Oh, look, Mayron answered this one. So, you know, giving an explanation as to why a particular answer choice is wrong that, you know, the student didn't understand. So some of them
it's just something I want to emphasize with that, because we have caved, we are uploading the incorrect answer choice explanations for every question. But again, just to emphasize, the process of struggling it with it yourself leaves the black letter law in you in a way that reading pre-written explanations just can't do.
Right. Thank you, Mayron. Again, convince yourself before you even pick an answer choice. And yeah, anyway, sometimes if you get something wrong, it's because of reading. And there's a torts question I'd love to do if we have time, but I want to make sure that I'm answering your guys' questions first. Is there a way to not show the scale of difficulty? Okay, this is great. This is somebody, David, you've been using BarMax. So if you look in the upper left-hand corner here, you'll see 2 dots out of 5. That means that our students have found this one only moderately difficult. And here, this is 3 dots out of 5, slightly more difficult question. right? So the most difficult ones, the ones that the most people miss, are 5-dot questions. If you don't want to see that, unfortunately, you have to be in test mode. If you don't want to be psyched out by whether it was an easy or a hard question, or do the questions on the browser, on the computer, or, just through the website, because that feature only shows up in the app and not on the website. So who determines the level of difficulty? It's just how many people are getting it right and wrong. Okay, if a lot of people are missing it, I think I just made some of those questions harder by choosing wrong answers. But no, I think that's already built in to which questions people get right or wrong. Are you comfortable with working with people who studied overseas? I studied in England and have a US LLM. We have students who have had such success with BarMax coming from other countries, but I want to let you know that I just had a student from Australia and another one from Ghana. Those are other common law countries who just finished tutoring with me, and I'm just extremely confident that the common law preparation that they got, and I'm sure in England you probably did as well. Mayron, did you have more you wanted to say about that? No? Okay, I thought he might.
Well, so we obviously have our foreign trained testimonials, which I think are really great to just get a sense of how comprehensive BarMax is, right? We're obviously about studying smart. We don't want to overwhelm you. But at the same time, it's more than sufficient to put you in a position to pass. And I think our success with first-time international students without any previous exposure to American jurisprudence really emphasizes that. So if you want to check out some of those testimonials, they are available on our website.
Right. This is just a few of them here that I've put on the screen because, yes, I have to remember to do that. And I think we're awesome, but I have to let you know that many of our students do too. We have retakers, and we have foreign trained attorneys, and we have people with other obligations who manage to study in a way that works for them with BarMax. And we're super proud of that. We're super excited about that. So Texas does have its own procedure and evidence rules, and that's only on the writing part. Oh, Bahara, hello, Bahara. I have tutored Bahara. I'm sorry, should I admit that? Yes, it's good to see that you're here. It's good to see that some of my students are here. In California, the federal rules have to be followed. Okay, so for the law of evidence in California, when you take the multiple choice portion of the bar exam, all of the questions are taking place in a federal court. So if it's in a federal court, you need to know the federal rules of evidence. If you're doing an essay and it's an essay question taking place in a California court, you'll need to know the California rules of evidence. So again, we'll have a whole session on California essays, but for the multiple choice, you do need to know the federal rules of evidence, and there are some differences. If you look in the California outlines, we have we've put in distinctions, especially in evidence, one of the big distinct areas. Do you think those of us who did not go to the law school in the US are disadvantaged when it comes to taking the bar? Look, I think civil law countries have it harder because you didn't cover any of these subjects, and you will need to give it more time and maybe tutoring. I think for those in the common law countries, there's some subjects you don't have, like our civil procedure rules and our Constitution, but the common law subjects you'll find refreshingly familiar for those who come from common law countries. So I think it does depend a little bit where you went to law school. How do we manage the time for 100 questions? Sunil, that's a tough one. I can see that you're I don't know, that's a matter of kind of partly speeding up your reading. If you're gain familiarity with the questions, but then work on speeding up your reading in with this material and other material, because that's pretty slow. But first do them slowly so that you're understanding them and getting them right. And then I do have, I do tell people who are just a few questions short at the end, like, okay, if you're always just a couple questions short, give yourself permission to skip, a property question that takes up a whole page. But again, pacing is something we worry about usually closer to the exam. Most students right now need to be worried about comprehension, about really recognizing the frequently tested rules and fact patterns. Wow. So Anonymous, who's frustrated with missing by 2 points. I'm so sorry, Anonymous. That's horrible and heartbreaking. I'm hoping that that seeing this study method that I showed today will help you feel like, maybe you have a different way to attack the questions that you're not strong in. But of course, you need to study all of the questions so you don't forget. Will there be blended questions? That's a great question. On the MBE, the answer is supposed to be no. But you just heard a but coming, didn't you? Sometimes you'll be looking at something and it feels like a civil procedure question because it'll say, should the court grant defendant's motion for summary judgment? But it's a torts question. They want to see if you know the elements of the tort. Okay. So sometimes you can't 100% tell because you have to know the procedural, you have to know what a motion for summary judgment is in order to answer the torts question. Okay. So sometimes you'll see something, or people were like, there were too many questions about jury instructions. And all they were testing was whether the judge had correctly stated the substantive law. So it may not have been a Civ Pro question. It may have been a question about the substantive law. So again, by doing real questions, you'll start to see the ways that they're tested, but they're never attempting to test the same thing, like not criminal law and evidence, not like that, no. But you do need to know something about, let's say you're answering an evidence question and you need to know why that evidence is being proffered in order to apply the correct evidence rule. So if you don't know anything about the underlying crime, for example, if you don't know that there's, a certain mens rea to larceny, then you might not understand the relevance of the evidence that's being introduced. So yes, you do need to know some of the topics in order to do well in evidence and civil procedure. You do need to be pretty confident on some of the underlying law as well. So it does all go together. And as you study, you'll get better at all of them. Oh gosh. Mary, how to combat remembering the questions. Take a little break. And then just don't rely too much on your percentage, right? Understand that your percentage is not going to be 100%, reliable, right? As it would be for somebody that's taking the OPEs and has never seen them before. But so don't count on that as a benchmark. Just use them because that NCBE will repeat the same sub issues and similar fact patterns and things like that. Special notes for Texas. It's going to the UBE next year. Texas is one of the 3 bar exams I passed, okay? I've moved around a lot in my storied legal career. And, if you decide that you want to use BarMax for the MBE, you would have to snag some other materials for Texas because they really are weird on their own procedure stuff. Or just put it off until it's the UBE because honestly, the UBE is a much easier exam than the Texas bar exam, but you sound like you can do it. So yeah, be brave. Either way. So what I did when I had to study for my 3rd bar exam, and I had been a law professor by then and really wasn't keen on taking a bar review course, is I did buy some materials on eBay, like, other course materials that people were selling on eBay just to get outlines for my state's specific subjects. So that's one thing that people can do. Let's see. Are there any jurisdictions that allow you to multi-state out of the bar exam? Well, no. No, I don't think so. No. In our book, we have 400. Are we able to print the questions from the app? No, there's not a printable form of those questions. So do the NCBE release questions provide reasoning as to why? Okay, so that's Jonathan, that depends on which batch of NCBE questions we're talking about. Let's go back into BarMax. If you look at all of our MBE questions that we have a whole section of MBE questions, the subject by subject ones, the online practice exams, and then this little magical thing called the MBE study aid. They have answer choice, they have correct answer choice explanations only that came from NCBE. And NCBE, like if you took the online practice exam with them, you would see the answer explanation for the answer you chose and which answer is correct. You would not necessarily see the explanation for the correct answer. If they haven't changed it, they may have changed that, because the last time I used that tool, again, it was in 2015 that I used it. So that may have changed, but to my knowledge, there's no easy way to get all of the ABCD answer choices, even when they've written them. And for the study aid, oh no, for the study aid, they didn't provide answers at all, did they? I can't remember now. No, I don't think they provided answers at all. Anyway, so the answer is sometimes they do, sometimes they don't. It's not really reliable.
And just to emphasize, if they do, we provide those. So if they do provide the explanations, they are live. Those exact ones are live in BarMax.
Oh, okay, good. Good. If you don't know an answer, should you skip and go back later? You're at risk of running out of time. Should the goal be to answer all? No. Okay, so Candace, there is no penalty for answering incorrectly. So fill in a bubble for every question, okay? Basically, so you can mark the ones that you want to go back to. If you are worried about running out of time, you can, I mean, if you think you're going to go back to it, you can leave it blank, but you have to leave yourself time to go in and fill in, you know, B, or just pick a letter in advance and use that one for every one that you don't fill out. But I don't encourage people going back and second guessing answers that they weren't sure about. If you're like, well, I think it was D, but I kind of want to read it again. No, you know, don't do that to yourself. It's like a psychological like warfare thing that goes on in your head, and you'll change as many right answers to wrong ones as wrong to right. You know what I mean? Don't torture yourself. Is it doable to prepare for the bar following your program or working at the same time? Yes, Anonymous. Yes, but you have to like really be honest with yourself about your energy. I've had students who study really great for a couple hours at night, right? And maybe they're a little younger than I am, you know, and, you know, a couple hours at night and a couple hours on the weekend. You got to be really honest with yourself. But yes, absolutely. And our program is kind of designed for that, because you can do it in chunks and break it up as you want. I mean, people have used this while commuting. You know, people have used this while sitting in a park. Now you would have to appropriately show social distance, but you could do that as well. So yeah, it's really, it's the most flexible program when it comes to, you know, you'll get the online lectures. You guys also have access to chat. You can ask substantive questions from time to time, and instructors like me will answer them. Where in the course can I find the MBE question bank? Okay, so this is what I'm looking at here, and Carrie's interested in that. So when I go here, there's a little thumbtack in the upper right corner. It's kind of hard to see that I'm hitting it, but just under where it says that my battery is at 72%. We'll go ahead and plug in. Yeah, just under where it says my battery, there's a little thumbtack, right? So if I click the thumbtack, I have a choice between which course section I want to be in. So the MBE question bank is here under MBE questions. And then, you know, the full course is here. When you do a section in the full course, like, you know, harping on real property, you'll notice that there's you know, there's the lecture, there's flashcards, and then there are some multiple choice questions on that particular topic, right? So the multiple choice questions are kind of located different places. And then in terms of doing it topic by topic, that's down here in analytics, which is, I'm clicking the menu at the top left under where it says what time it is. Yeah, so there you go. That's where you find it in BarMax. I'm typing the test. Well, I have a pencil and test booklet to underline and highlight, and then a bubble sheet to fill in. And Michael, yes, that's exactly the typical format, right? You'll have a test booklet, and you can bring in pencils, and bring in lots of pencils, obviously, because highlighting, underlining is really useful. Now, that's all with the caveat that we don't like end up in this pandemic situation where suddenly we switch to remote proctor electronic exam or something. If that were to happen, and that was a question that I got, like, how would we take an MBE test if it were remote? And the answer would be, gee, it would look a lot like BarMax. You know, it would look a lot like these questions that we're doing here, because that's kind of what happened with our LSAT product. You know, TestMax has LSAT Max and BarMax, and the LSAT recently went to all electronic, and you know, and they take it on tablets, and lo and behold, it looks a lot like our interface. And you know, LSAT Max made some adjustments to make it look like the interface. So if it is electronic, it will be like that. But otherwise, if that strange thing doesn't happen, then yes, you get a test booklet and some pencils and a Scantron to fill out for the bubbles. I have the full California course. Where do I find the outlines? So the outlines are under, you know, your full course will look like this. It just has different subjects. The outline for each subject is right here with the lecture. Okay, so it's with the lecture. You can play the lecture, or, well, I shouldn't have done that. Now it's going to play. It's probably really loud. Anyway, I'll turn it off. So yeah, you can play the lecture, or you know, that have the outline there, or the printed California outlines. Like, we can send you books. California. Okay. Can the MBE be taken? It's a paper test at this point, Natalie. It's only a paper test.
The next block of materials I'd like to talk
Okay,
about.
that's Arthur Miller. There we go. Turned him off. What can I use for the Hawaii bar? Okay, Jesus, this is for you, for the other Hawaii person, the Nevada person. Here's what, if you like the BarMax interface and you want to use BarMax for your MBE, then again, I just recommend two things. One is get outlines for your state-specific topics secondhand. The second is go to your state's website, bar website, because they have past essays in almost every state. They have a big bank of past essays, and they usually have high-scoring student answers, which may or may not be great, but at least it gives you some idea what they were looking for. Or some states actually publish like a little scoring guide, so you know what they were looking for in the essay. Georgia, for example, does that. So use those, study from the old essays for your essay topics, and then either take the MBE course with BarMax, or if there's a lot of overlap between your essay topics and the MBE essay and the UBE essay topics, you could take the UBE course. I had a Georgia student who ended up doing that. She took the UBE course because trusts and corporations, agency and partnerships was all the same. And she wanted our material for that, right? So then she had to learn some Georgia stuff too. And she had separate materials for that and studied, you know, from the Georgia essays. So that goes for any state that's not California or the UBE. You can either use our MBE course or our UBE course, and then supplement as necessary with commercial outlines and valuable materials on your state's bar website. Go, you know, scrounging around. I have this huge binder, it's up there, of Indiana essays, because I've taught Indiana. And like, it's this big fat binder of all the essays that Indiana has used for testing for the last, I don't know, I have like about 10 years worth in there. There's more online. How do you go back and erase answers to the multiple choice questions? Let's do that now. So I'm going to go into my profile, and I do this before I meet up with a new student anyway. Clear multiple choice history, delete. Okay, so here's the only problem. You clear everything at once. Okay, so now I have no analytics. I have no questions marked to any portion of the course. But I think that's good. It's good to look at the questions with fresh eyes from time to time, right? So there you go. This was helpful. I was not using the open book method. Polly, it's going to be uncomfortable at first, but give it a try and then let us know. Let us know how it goes, okay? Would we be able to apply the techniques? Oh, you want me to do another question? I did one full question. Well, let's see. We'll see if we have time. Estefania, because I prepared like several questions, but you guys have. Why is California more difficult than New York? I don't know, because California thinks it has too many lawyers and New York doesn't. I don't know. New York has a lot of lawyers. It's just the way it is. California has always had a very difficult bar exam. New York's used to be one of the most difficult, but then they caved and went UBE and everybody was shocked. So California is definitely up there, you know, on the top of the mountain in scale terms of difficulty, anonymous, and you know, you just have to buckle up and do it. You want to live out there, so you're going to make it happen. I know you will. How well do we need to know the black letter law, i.e. article number, name of case? You don't need to know article numbers except for like major like parts of the Constitution, okay? You need to know parts of the Constitution, but let's say you're answering a contracts question and it's about, you know, the Battle of the Forms. Okay, I was a contracts professor and I deal with BarMax a lot, so just the fact that I know this, whatever. It's UCC 2207. You do not need to write UCC 2207. You just have to know whether the additional terms become part of the contract or not. Oh my gosh, I'm giving you nightmares. I'm bringing back your first year of law school. So yeah, you don't need to know the numbers. You need to know major sections of the Constitution and maybe a few big name cases in constitutional law in case you get an essay, okay? All right, that's it. I did how to reset your Q&A in BarMax. What is the ratio between most difficult versus easy questions? I don't know, Lugos. Some of each. Just keep in mind, if you get about 62% right, you're probably going to pass, depending on your jurisdiction. If you're in California, make that 66, right? And be a good writer. You know, and then you don't have to be a great writer. You don't have to get as many right. So I don't know the ratio. Just some of them are darn near impossible and make everybody want to tear their hair out. It's just the way it is. They like to torture us. Chinwe. Yes, so Chinwe, we are working to build out wrong answer choices, but as you asked toward the beginning. So I think if you're still here, you saw my explanation for why we want you to come up with this itself. Oh, someone who purchased the app several years ago is studying now, wants the book. So you can message customer support from the app and purchase it there, or you can call customer support and just purchase it. It's $100 to get the book because we didn't used to have a book. This is, you know, BarMax has improved a lot over the years. We've always had flashcards, but we're working on improving those. We're adding this kind of product, and then office hours, which is like this, but maybe 100 people, and you know, we you know, a little bit more opportunity for Q&A. So yeah, we have a lot more than we used to have with the program acknowledged. So if you want to buy the book, it just, you know, it costs $100. How do I So I answered that one. If you have a 2019 book, but you can still use it, what are the changes? How do we get them? Okay, so when you're looking at the outlines on, first of all, update your app. Okay, somebody who has a 2019 book and wants to keep using it, update your app periodically. It will delete your answer choices. So be prepared, it will reset, but it'll also give you any updated material will be in your outlines, because we do periodically update the outlines you know,
So
we're
just
doing
jumping
that.
in real quick. So that's not accurate. So it doesn't actually delete your progress. It'll just take some time for it to sync back up.
Oh, I didn't know that. I didn't know that. I don't delete my app very often. My bad. Thank you, Mayron. It doesn't delete it. So just then definitely delete and reinstall your app from time to time, and you'll make sure that your outlines, the versions that you're looking at on the app, are the most current up-to-date changes. Also, anything on the website, anything you access through a browser is always the most up-to-date version. When there's new language, sometimes we highlight it in red. Yeah, so you
also
should
just to clarify too, you don't actually need to delete the app and reinstall it to get the latest updates to the content. You also, if there's an update, you just need to update it. You don't need to delete it. But the content in terms of the outlines will update automatically anytime you connect to the app with internet. So if you open the app with an internet connection, it'll pull any updates. So for those of you who are really taking advantage of the ability to use it without internet, definitely every now and then connect using the internet so it can pull the latest updates off the server.
Okay. Michael from Ghana, another student from Ghana. That's awesome. I had a wonderful student from Ghana, and you said you've gotten good recommendations, so thank you. It's nice to hear that. Do I suggest that foreign learners take more time with the course? Yeah, again, Natalie, you know, I had a student, again, I'm just using my Australian student as an example. She studied in a pretty standard amount of time, but she did include tutoring, and she was extremely like driven and self-directed and you know, made her own, you know, like she had a barrage of questions that she sent me in advance every time. So she was very engaged in learning the American law material. A very, very high powered attorney in Australia. So, you know, depending on like, if you need more time to like chew on stuff to get it, then give yourself time, you know, give yourself the time that you need to make sure that you comprehend and understand the law that you're learning when it comes to the new stuff, the civil procedure, the constitutional law. Oh, it's like starting all over again. Yeah, well, start over. There's no place to start but the first step, right? That was back for Michael. So I'm sorry I misspoke about the app, but I'm glad that we're getting better information from Mayron. I clearly handle the content side and not the text side. And luckily at BarMax, we have really good people on the text side. So normally I'm only responsible for content. I'm not sure, Rajesh, that I understand your question. I don't know if you're still here, but I'm not sure I'm understanding. Oh, I think you were asking about clearing it, or no, no, should I give? I'm not sure what the SA exam is. So I have more international student questions. It's a little bit beyond the scope of just the MBE material we're covering today. Yeah, so when you are studying open book, Henry, we do, you know, when you select the answer choice, it will show it. And I think we demonstrated that. Do you recommend taking the time to put the BarMax CBE outline into your own words? Well, that's interesting. That gets to David, like we'll talk about it closer in an office hour, closer to the exam, but best memory strategies. I don't think necessarily the whole outline, but I think for some people, like rewriting your own outline of the most important parts, the most tested parts is absolutely the best way for them to learn. Other people learn well through flashcards. So it's just depending on the learning style that works for you. If you've done that and feel comfortable with it, then go for it. That's similar to what my Australian student did. How does the tutoring program regard to MBE. So here, hang on. I didn't show our programs. I was supposed to do that, but I got so much Q&A and I want to talk to you guys. So it's here, down at the bottom. Okay. We have, these are our courses. We have the UBE in California and MBE courses. These three right here are our three. These are our comprehensive courses, and then this is MBE only. But again, if you're in a state that's not UBE or California, but there's a lot of overlap in the subjects with UBE, like take a look. If there's a ton of overlap in the subjects, then this might still help you. You just need to get state-specific outlines, like, you know, to learn your state distinctions, secondhand material online from some other company. This is tutoring. These are packages that we have. Again, like you can have, we have tutors available for UBE and California. If you just want to work on MBE subjects, you can do that as well. Yeah. So let's see. So thank you, Ezzy. And Susie, I don't remember if Virginia is UBE or not, and I don't have that open. If it is a UBE state, you need to check. If it does the uniform bar exam, then yes, you can use BarMax only to prepare and pass. If not, you'll have to follow that other advice I gave about other states. We do provide a sample study timetable. That is great that you asked. So we provide a calendar that is available for download with our welcome packet when you purchase one of our programs. The calendars right now are geared for the July exam. So we need to redo calendars for the September exams, but if you want to start now, you can create one for yourself, just kind of, you know, push the days back. By open book, do I mean the hard copy? Actually, it doesn't have to be the hard copy, Evelyn. It can be the hard copy or using an online outline. And then what practice do I recommend for studying? Yes, if you haven't taken a bar exam lately, if this is new to you, listen to the lecture and read the outline together, and then do practice questions that are available after each section of the outline, okay? That's how I recommend that you do it, that you listen to each little section of the outline. You've got, you know, your pleadings. So don't listen to the lecture and the outline separate, just look at them together. Or, you know, if you're listening to the lecture on the go, that's okay, because you're going to refer back to the outline when you do the questions. So you've listened to your lecture on pleadings. You can look at some flashcards on pleadings. You know, you can sort them into the ones that you got right and the ones you got wrong. So you can go through them again and again and say, oh, I didn't know that, you know. So after you've done your lecture, you can use flashcards and multiple choice questions on that particular topic to reinforce that concept. There's just 2 pleadings questions here, but it's to reinforce what was in that specific lecture. And then when you're done with all of civil procedure, I really recommend that you go to those study aid questions down at the bottom of the MBE page, because those are the most recently released and they're good questions for studying first in any given subject matter. New York does, oh, the New York law test. No, you're going to need separate materials for the New York law test. We just will teach you the UBE part. Evelyn, how can you have a split view of the outline and the essay workshop in one page? Evelyn, when you get BarMax and download the welcome packet, you can have the essay, oh, not the essay workshop. I don't know, you might have to open a separate window, would be the only way to do that. But you will get PDFs of all the essays as well as the NCBE answers. Do you need to print out the past essay questions? Jane, if you want to work from printed material, then yes, you can print the questions that you want to do because we give them to you in PDFs. You don't have to do it from the California website. We're going to give you all of them. We give you all of the past California essay exam questions. And I explained how open book works. It's when you go and you look at your outline. Got it. Thank you, Polly. I was delayed and missed a lot. Yes, there will be a replay. Stacy, don't worry, there will be a replay. I'm wondering if all of you folks are still with me. But yes, there will be a replay. You'll get, there's going to be an email you're going to get with a nice discount offer, and then a link also to a replay of this session. So 2 kids, full-time job, non-legal. Any recommendations for you to study and pass? Yeah, just like you have 2 kids, you know how to schedule. If you have 2 kids and you work, you make your plan and work your plan. You plan your work and work your plan, right? Plan your work and work your plan. That's my advice for you, Melissa. Set up your schedule so that you have study blocks that are protected, even if it's just like 2 hours or even 90 minutes, but protect it, right, throughout different parts of the week while you're balancing your other responsibilities, and give yourself plenty of lead time so that you can get through the material that way. And then hello from, we got the Nigerian people connecting, of course, you guys are everywhere. And when do you suggest we start working with a tutor? As soon as you think that one will be helpful. You can meet as often or as infrequently as you want. I have a student who's been studying over long term and she just checks in every now and then. I have other students who meet with me every week. When it came right before the bar exam, I had one woman who wanted to meet with me 10 times in 2 weeks. I don't actually recommend that as like the best way, but she realized she needed extra help, and hey, we got a lot done. We got a lot done. So I'd say as soon as you think it would be helpful, then start, and you don't have to commit to any particular schedule. The way it is, you purchase the package and you get to sign up for the hours of that tutor's time that you want, and you can reserve them in advance. And as long as you cancel at least 24 hours before, you can even cancel. So it's a really convenient scheduling function that you are able to use to use the tutors when they or we are most helpful to you. Little worried about typing speed. Okay, here's the thing. You need to learn to write succinctly anyway. They would rather have a succinct, to the point answer, okay? And IRAC is the best essay structure, and we're gonna have a whole webinar about essays. So do practice typing, but I would worry more about being direct, concise, and using a very clear IRAC than I would about your typing speed. Okay, so the welcome packet is, well, I don't have, it's actually, you can only get the welcome packet on your laptop. So when you open the profile open your profile, you can see it says welcome packet right below it, the profile, the little picture of a shadow of a head. Okay, that should help you, Jennifer, get to your welcome packet. Let's see. How much if I only purchase all the New York essays? We don't sell the New York essays a la carte. We sell the UBE essays, which are the main, the MBE, the multi-state essay exam essays, as part of our UBE packet. And we don't have, so it's part of the uniform bar exam course. You get all of the essays, and I had that up. That is, that's one of the comprehensive courses right here. Wow, I really scribbled. Anyway, it's one of the comprehensive courses. So let's see what else. Can all the replays be incorporated into the BarMax app? That's a question for me, Ron. I got to answer just MBE specific questions. Maybe someone from BarMax can answer that, but I know that we're going to have replays of the office hours in the BarMax app, and you're going to have a link to look at it on any other format. And I think that's it. I think I've answered most of the, how far in advance do people start studying? Here's the thing. If you're studying way in advance, I recommend people work on skills and first and basic knowledge. Like if you're having trouble with writing, when you get BarMax, you can submit a certain number of essays. I think it's 10 essays for review. And then you can purchase more essay reviews if you want beyond that, but you get 10 essays for review. If you submit them one at a time, you'll get really good feedback about your writing. And you can do that with your performance tests as well. Your multi-state performance tests, which is on the UBE, or your California performance tests, they're the same format now, that 90-minute format. So you can submit those and work on developing that skill now, and then start spending time making sure you comprehend the material. You're gonna have to do another whole review through all the material again, closer to the exam, as you're working on the memorization part. But you wanna work on the comprehension part well in advance if you are giving yourself a lot of time. So your skills, your writing skills, and your performance test skills, and then your comprehension and understanding how the MBE law applies, taking your time to do that is something you can do in advance. And then you will ramp up a little, and you need to give yourself some time to ramp up a little right before the exam, the 4 weeks or so, 4 or 5 weeks before the exam, to make sure that your memorization is on point as well. So we've answered everything. We went way, way over time. I was thinking this might go an hour and a half. we're at an hour and 45, and there's still 400 of you finding this worth your time, or who couldn't figure out how to leave the meeting, one or the other. Since that's the case, I'm going to go ahead and do one more question, okay? Because that's really what I'm here for, is to focus on the MBE. And I just want to show you what to do if you get to a question where you know the law, or you think you know the law, and you're down to 2 answers, okay? Because that comes up a lot. All right, actually, I'll use my contracts question for that. I have so many questions here. We're not going to get to too many of them. I know I had a contracts question. The contracts question is the good one for us to use if we think we know the law, because we're going to all pretend that we know the parallel evidence rule, okay? All right, some of us do, and you will, I promise. But anyway, let's look at this. It says, is the court likely to admit the evidence of the orally agreed price of $100,000? Okay, this is looking a lot like a parole evidence. Now, whether you say parole evidence or parole evidence is fine with me. Different people pronounce it different ways. As long as you don't put an E on an N when you write it, we're good, okay? Is the court likely to admit evidence of the orally agreed price of $100,000? What do we do after we read that? We go over here, because this is all correct information. We know that 3 of these are incorrect, so we're not going to look at those yet. We're going to go over here. A buyer expressed interest in purchasing an industrial air conditioning system manufactured by the seller. The parties agreed orally on a price of $100,000 for the system, but continued to negotiate over several points. So I noticed they've agreed orally, and that's $100,000. Now, you know, I might be thinking statute of frauds here, right? Because I'm like, whoa, this is a sale of goods more than $400. I don't know, it's an oral agreement. This is nothing to me, right? But I know from reading this that what I'm asking about is the admission of the evidence. So we're going to keep reading. They continue to negotiate over several points. When all matters regarding the air conditioning system were finally settled, The parties signed a written agreement. It provided that the price for the system, which would be delivered June 1st, would be $110,000. The written agreement, a lengthy form contract, did not contain a merger clause. That might be relevant or not, we're not sure. The seller delivered the system on June 1st. Okay, so it looks like we have, you know, some kind of performance here, check, check, right? But the buyer refused to pay more than $100,000, citing the earlier oral agreement as to price. The seller sued the buyer for an additional $10,000 under the written agreement. Okay. Now we read the question again, remind ourselves what's going on. Is the court likely to admit evidence of the orally agreed price of $100,000? All right, so we have these people who agreed orally to this $100,000 and then signed a written agreement, negotiated more, signed a written agreement for $110,000. So does that written agreement control, or can other evidence be introduced? And does this matter, the lack of a merger clause? Let's keep reading. Let's read the answers. No, because the buyer assumed the risk of any mistake as to price. Okay, it doesn't indicate that there's been a mistake here. It looks like a different agreement, and it doesn't say that there's a mistake. So this is like coming out of left field and doesn't look like a very convincing answer. B is no, because the oral price term would contradict an express written term of the agreement, or express term of the written agreement. And if we know the parole evidence rule, we know that evidence cannot be admitted that contradicts an express written term in the agreement. This contradicts, this contradicts. So we like this answer a lot, okay? But we're gonna keep reading just to be sure. Yes, because the oral price term is relevant to whether the writing should be reformed. Again, nobody's talking about a mistake here. What we're talking about is continued negotiations, okay? And then yes, because the written agreement did not contain a merger clause. And this is the answer that's going to get a lot of people because they don't know the parallel evidence rule. But we're going to pretend we know it, okay? No, actually, no. For this one, actually, we really need to look at the rule. But we'll look at the rule. You saw how we did that. We can use the book. We can use the app. When we look at it, this isn't the one where the facts are kind of squirrely. I have one where the facts are squirrely, and that's a torts question. I realized maybe that would have been good too. See, I want to do them all. Anyway, this one here, you know, if we're not sure between these two, this is where open book method tells us we're going to look at our outline now and be sure. But if we know our parallel evidence rule well, we know that it doesn't matter whether an agreement is integrated, completely integrated, or partially integrated. It doesn't matter. A written agreement cannot be contradicted by prior inconsistent oral agreements. It can't be contradicted. The whole question on, you know, full versus partial integration tells us whether or not we can supplement that agreement, but contradictions are not allowed. So that gives us this correct answer. But in an open book method of study, we would have gone and looked at the rule if we didn't know it. If we didn't have a contracts professor here talking to us, telling us the rule. The torts question I wanted to show you, you know, is really, really fact specific, and this is going to be the last one I do, and then we're probably going to close out. We looked at this one, we said in an action, or we didn't, we skipped this one. In an action for battery brought by Karen against John, will Karen prevail? We have a battery action here. We have Karen crossing Main Street at a sidewalk and John seeing a speeding automobile heading in Karen's direction. John ran into the street and pushed Karen out of the path of the car. Karen fell to the ground and broke her leg. Okay, will Karen prevail? Well, if we look, we see the prima facie elements of battery here. Okay, let's say we know our torts really well. There is an intentional contact, right? He intended to contact Karen. Okay, and it has to be harmful or offensive. This was harmful. It broke her leg. So we meet the prima facie elements of battery. The question is, does he have a defense? Okay. And A is yes, because John could have shouted a warning instead of pushing Karen out of the way. This question, when you see the word because in an answer choice, that's only a correct answer if everything after it is true. And if we look, the facts don't tell us anything about that he could have shouted. We just see a speeding automobile. We don't know if there was time to shout or not. We can't make stuff up. We can't assume facts. Sometimes when we get one wrong, even when we know the law, it's because we're allowing ourselves to assume facts. We're not going to do that. Okay. Number 2 is, can Karen prevail in a battery action? Yes, if Karen was not actually in danger and John should have realized it. This is another reading thing, because when we have an if in an answer choice, we're taking this new information and inserting it into the question. Okay, if it's if and then some new facts. So now we have to read it as if he saw a speeding automobile headed in Karen's direction. Karen was not actually in danger and John should have realized it. And John ran into the street and pushed Karen out of the path of the car. Suddenly, John's looking like less of a hero here. But so this is a good potential answer. C, because the driver of the car was responsible for Karen's injuries. This is trying to pull us off track. We're only interested in litigation between Karen and John. If there was some negligence or some other, problem on the part of the driver, well, maybe we can, John can sue him later for indemnity or, or can bring him in and have their joint tort. I don't know, whatever, but we don't care. We don't care for this question. We don't care at all. Okay, that's a bad answer. This is the one that tends to trick people. No, if John's intent was to save Karen, not to harm her. Okay, so in this one, John is a good guy. Okay, so here we have an if, we insert these extra facts. Okay, John saw a speeding automobile. He ran out into the street and wishing to save Karen, not to harm her, pushed her out of the path of the car. Was that a privileged action? Well, if we know the rule for self-defense of others or defense of others as a defense to battery, we know that the perception of danger, that the other person's in danger, has to be reasonable. So if this one is true, then this one doesn't matter. So what? And if you have a so what, it's the wrong answer. Okay, the correct answer here is B. If Karen was not actually in danger and John should have known it, then Karen will prevail in a battery action. So all of that, doing this question is just to show that sometimes when you're reading, like you might know the law, or you might go look it up and you're still torn between answers, choices, and it's just a matter of either reading the facts more carefully. In evidence questions, oh man, every word sometimes matters. In a lot of these questions, every word matters. So you want to read the facts carefully, but you also want to read the call to question and the answer choices carefully, because if you're stuck, there might be something you're missing there. Or if you have two things that look like good answers, you need to ask, well, if this one is true, does the other one matter? If it's true that John's intent was to save Karen, not to harm her, it's still not looking good for him if his actions were totally unreasonable at the time, okay? Because defense of others needs to be a reasonable belief that the other person is in danger. So that's it for actual questions, since somebody asked me to do more than one and I thought that was reasonable. You guys are chatting with each other. I told you to do that in chat and just put questions for me in Q&A. And Amber, I hope I just answered your question. When you're down to 2 answer choices, look back at the facts and look at the call, the question, the wording of the answers, and figure out if it isn't a more careful question of reading. Okay, if you know the rule stone cold and you still are torn between 2 answer choices, there's something in those facts or in the way the answer is written that's intended to tip you off. This is not choose the best of 4 answers. Really, the way they phrase things, 1 answer is right and 3 are wrong. And there's a reason, okay? So try to convince yourself. And if you finally are tearing your hair out, you can't convince yourself, then fine, select one and read the answer explanations given. But by then you've done all the work of looking up the rule, of reading carefully, of kind of questioning yourself, convincing yourself. What New York essays? Okay, so there is an additional portion of the New York. It's not the bar exam that you take on the 2 days of the bar exam, Carrie. There's like a New York law practice test. I apologize, I can't even remember the name of it. It's like an extra thing. I think it's online. You want to chime in here? New York NYLC. Anyway, it's not part of the bar exam that you take on, that you'll be taking in, depending on jurisdiction, July or fall. You'll be using the regular UBE essays as everyone else, Carrie, in New York, and you only need to know the generic UBE law that is taught in any jurisdiction that's taught throughout the whole BarMax course. So I hope that gives you some reassurance there, but there is like an extra thing that New York makes you do after. Are you guys answering it in chat? I don't know. Anyway, yeah, I can't, I'm sorry, I don't know that off. I really got to stick to my MBE. That's what, okay, and I've answered that one. I think we're good. I think I got most of, could I do so what again? Yeah. So what is really helpful, isn't it? It's 4 o'clock, guys. I got to get going. Woo! Anyway, so what is really helpful? If you look at an answer question and it gives you some facts that ultimately don't matter to the outcome, then you can tell yourself, so what? If John's intent was to save Karen and not to harm her, but he was otherwise culpable, then so what that he intended to save her? Does it matter? No, because the rule is that his belief needs to be reasonable, okay? And this answer tells me that it's possible that we could have a scenario where Karen is not actually in danger and John should have realized it. So if that's true, then the other one doesn't matter. But if we flip it, if we try it the other way around, well, if D is true, does B matter? Yeah. If D is true, B is the one that still changes the outcome for John. Okay, B would still change the outcome for John. Okay, if D were true. So D doesn't matter whether that's true or not. B is still determinative. B will still lead to your answer, whether or not D is true. I hope that helps. As you do more of these questions, you should start seeing that. At what point should you start timing yourself? I don't know, 6 weeks before the exam. I mean, and then even then, just small sets, in our calendar, we have you taking the OPEs, the online practice exams, the 100 question tests, like I don't have the calendar in front of me, but it's like in the 4 or 5 weeks before, 6 weeks before, and those are timed. If you know that you have trouble with timing, you can start timing yourself on smaller sets before then, but I wouldn't do it too much before then. Just practicing a lot. See, I can't tell anybody what specific score you're going to get, Jessica, but I do recommend that learning the material as it's tested by going through real questions in this manner where you're actually consulting the outline if you have to. Okay, so people are asking about the essays in the welcome packet. Again, that's a little bit beyond the scope of the MBE workshop that we're doing here today. But in the welcome packet, you see analysis or an analysis for the MBE answers that is actually provided by the NCBE. It's for the people who are scoring the exam, what NCBE was expecting people to get out of it. And then for some of them, the more recent ones, you'll actually see some sample student answers. For California, you only get sample student answers, which are, you know, your mileage may vary. They scored high, but sometimes they threw in issues that were irrelevant, or, you know, they're not perfect, okay? Because they're just something that somebody did, you know, on the day of the exam under time pressure. Okay, so I think that's it. Wow. I'm so glad people found this helpful, that so many of you are still sticking around. It's like, you're still here. I want to keep talking to you, but I will, you know, you'll see me in office hours on BarMax, and you know, we'll be communicating with each other. Just buy BarMax so we can keep in touch. Okay. And whatever you do, good luck, and stay sane and stay safe through all of this. Okay. Bye-bye.